Professor Vervaele, can you explain us the concepts of extradition, rendition to, and extraordinary rendition? What would be the difference between these concepts?
Dear colleague, pleasure being here and thanks for the question. The extradition is a very classic concept of cooperation, normally between states, sometimes between judicial authorities in states, so prosecutors' offices or investigating magistrates, dealing with requests to transfer a person from one state to another state, so from the requested state to the requesting state, with the aim of bringing that person to the trial, to the criminal trial, or with the aim to execute convictions. That's the classic concept of extradition, and for this type of mutual legal assistance we have specific treaties, being treaties bilateral between the states or treaties in a multilateral frame, like in the Council of Europe where we have treaties, a multilateral treaty on extradition. That's the concept of extradition. Of course, this is a judicial procedure. It's about arrest, detention and transfer, the extradition itself. So it has to be approved by a judge. There are a lot of legal safeguards. There are, of course, thresholds of minimum of evidence, of suspicion, and so on and so on. That's the classic concept we have. If we jump to rendition to justice, you see already the terminology is changing. It's not extradition, it's rendition. There can be several factual things behind it. In cases in which states cannot use the extradition treaties, or if there are no extradition treaties in place, but they want to adjudicate a person for criminal liability anyway, but unfortunately he is abroad. How do you get the person to your tribunal? Then there are mechanisms that has been used by many states, let's say since the 1960s, to get that person to the trial court. The first mechanism is to use administrative cooperation between states. So not the judicial criminal law one. They consent to bring the person to the other state, but outside, circumventing the extradition. A classic example is what I gave also in the conference, is France and Spain. They had problems with ETA terrorists. The police of France arrest persons in French territory and put them at the border and give them to the Spanish authorities, circumventing the extradition treaty. It's rendition to justice. That means the aim is adjudicating people. So bringing them to trial, the criminal trial. That's the aim, but not using the classic mechanism of extradition. In my example here, in consenting authorities. Of course, avoiding all the safeguards and thresholds and requirements of the extradition treaty. So for the subject, for the person involved, it creates a lot of problems, of course, because it's an administrative procedure. The second step of rendition to justice is acting in the territory of another state without the consent of that state. So that means that agents of state A are going to state B, illegal, unlawful, and take a person away by force. As it is unlawful, because there is no consent of the state, it's a violation of the sovereignty of that state, and they abduct, they kidnap, they forcibly take the person from territory A to territory B. But still with the aim to adjudicate a person for criminal liability.
So, to sum up so far, in both extradition and rendition to justice, the purpose is to bring the person to justice, but in case of rendition to justice, you literally kidnap the person, but that can be with or without the consent of the territorial state.
Indeed.
So in the case of Öcalan, Turkey took him from Kenya. There might have been, or there might not have been, the consent of Kenya. That is not very clear. It would fall within the category of rendition to justice.
Yes, for sure. That's a classical example.
Okay, so now we come, I guess, to extraordinary rendition.
Yeah. Extraordinary rendition is it's a more recent phenomenon, because the other ones we have it for decades. with practices in Europe and in Latin America, and certainly also in Asia, but I know that less. The extraordinary rendition started, now we know it, because it has been secret programmed for a decade, started under the Clinton administration.
I forgot one thing we want to edit there.
Tabii.
The results of unlawful abduction. That might have come first.
Siz soruyu
Okay.
baştan sorun.
Okay.
You want to?
After the Kenya part, I could just
Yes,
ask
okay.
you, so what are the results of such unlawful abduction in terms of the trial, of the criminal trial of that person?
Yes, that's a specific focus. There we are not dealing with state liability. We are dealing with what does it mean when you want to adjudicate a person for criminal liability. The fact that he has been abducted and that the extradition proceedings has not been followed. We have a doctrine in international law that has been used also in criminal proceedings, and that is part also in many countries of, let's say, of the domestic principles, which is called in Latin male captus bene detentus. That means, in fact, the fact that you have been captured unlawful does not mean that your detention under the domestic regime, and also of course the trial proceedings, would be unlawful, or that your presence there would be biased by an unlawful act. So you can stand trial, unless the fact that you have been abducted, and still you can get a fair trial. That's male captus bene detentus.
So the fact that you otherwise comply with the requirements of the right to a fair trial is sufficient. The way you were actually brought before that court becomes irrelevant.
Indeed. Yes.
Okay.
Yes. That's a standing doctrine. Of course, you can criticize it, but standing doctrine.
And with regard to the doctrine of the U.S. Constitutional Court, do they adopt a different approach?
But that's from no, but they have another approach to this phenomenon, because also this doctrine of male detentus is applicable in the United States. But the problem with the United States is that when it comes to applicable we are still speaking about rendition to justice. When it comes to applicable constitutional standards, that means U.S. standards of the U.S. Constitution, to their agents, military personnel, police personnel, FBI personnel, CIA personnel, intelligence forces that are active abroad, outside of the territory of the United States, and abducting people. When they abduct people, so always with the aim to bring them to justice in the US, do they have to apply US constitutional standards while acting on foreign territory? The answer of the Supreme Court has always been no. So that means that, like in the Noriega case, the former president of Panama, who was abducted, that he cannot claim application of US constitutional standards to his abduction.
Okay, very well. So now I think we can move on to extraordinary rendition.
Yes. So under the Clinton administration, so that's of course quite a lot of years ago and far before 9/11, so 2001 and the terrorist attacks in New York and Washington, the Clinton administration elaborated a secret, at that time secret presidential prerogative to establish a new program giving a legal basis, based on presidential powers, a legal basis not only to abduct people, to bring them to justice in the US, to criminal justice in the US, no, to abduct people in foreign states, to transfer them to third states. So let's say to abduct a person in Italy or to abduct a person in the former Yugoslavia and to bring him to Syria, to Egypt, to Libya. I address these countries because they were mostly the destinies. And what was then the main aim? To detain them there, to put them in security detention. So that's limiting the risk, the threat, the harm, because these persons that were abducted were considered by the US as a threat to national security. But not only to secure them there, but to submit them to what in the US is called tough interrogations. We would say torture. So that's a complete other philosophy, because the aim, the objective is not anymore standing trial, bringing to justice. The aim is securing, locking up, and getting information with the most tough techniques that, of course, when it comes to torture, are completely unlawful under international law. You would say they're also unlawful under US law. With this doctrine of the Supreme Court, it doesn't matter because everything happens outside. And second, they are not brought to justice in the US. It doesn't matter. That's the extraordinary program. It has been set up by Clinton after 9/11, so the terrorist attacks in New York and Washington. It has been expanded by the Bush administration under emergency procedures, emergency measures after 9/11. So it has become a common practice. The figures that we know are there were extraordinary rendition cases before 9/11, let's say near to 100. So from the Clinton administration until 9/11, so 10 years more or less. And then since the Bush 1 program, the calculations, but that's more difficult to know for sure, because there has been no official declarations about it, but the calculations are near to 500. The program did not stop under the Obama administration. So it's a running program.
So what is the applicable legal framework under international human rights law to security detention? Is there a specifically applicable framework, or do we have to turn to the general rules on detention?
Yes, that's a very good question. It's also it's not an easy one, because we have under international human rights law, of course, the whole reasoning of emergency powers. We can suspend certain articles, derogation. That's, of course, I didn't deal with that in the conference because it makes it even more complicated. But if we remain into the classic frames, let's say the ICCPR, so the convention, the Covenant on Civil and Political Rights of the United Nations, or I gave the example of the Inter-American Convention of Human Rights, or the European Convention of Human Rights, our reality, when there is no suspension of rights under an emergency procedure, Article 15, then the question, of course, security detention in the framework of terrorism and emergency situations of terrorism and special threats. Is there a special concept of security detention under, for us, European Convention of Human Rights under Article 5, so the right to liberty? The answer of the European Court has always been no, there is not. That means that the clauses that have been foreseen under Article 5, so we have to do with migration, with criminal proceedings and so on, are the only clauses. So it is important to know we cannot invent something outside of this framework. However, when we are within the framework of Article 5, and so we have to assess the criteria, still we can ask, how long can you lock up a person because he's a threat or a possible harm? You don't want to bring him to criminal justice. You don't want to bring him to migration proceedings. It's just because he's a threat. How long can you do that? The period of time. Second, what should be the threshold for locking up someone just because he's a possible threat? How much evidence do you need? Must there be a specific legal basis to do so? And who should check that? Because the decision is mostly, in this case, is taken by executive body, so by bodies of the government. So there must be judicial control. These are the criteria. If you compare all this case law at the UN, case law at the Inter-American Convention and Court of Human Rights, and case law at the European Court of Human Rights, today, because there has, of course, been an evolution, you could say this is not. It's not a specific criterion, but this is possible within, for instance, Article 5. So you can reason a security detention, but for an extremely short period of time, 2 to 3 days. There must be a legal ground to do so. So it must be foreseen in your domestic law, must be clear and foreseeable. Of course, the evidence must be enough to justify it, to avoid arbitrary decisions. And within 3 days, there must be a check, so an assessment by an independent court. That means the habeas corpus procedure does apply.
So in parallel fashion, Would you argue that bypassing existing extradition procedures is unlawful per se, or would it be lawful subject to the criteria you have just explained?
Yeah. There we have other case law, a lot of case law of the European Court of Human Rights. They do not impose as such for transferring one person from one jurisdiction to another jurisdiction, from one state to another state. They do not impose as such the extradition treaties. Of course, the extradition treaties between the states do impose the duty to work on the extradition treaty, but the human rights standards do not impose it. So that means you might go to parallel proceedings, administrative ones, style rendition to justice, not extraordinary rendition, because you have already seen this has not a name to bring to justice. If you choose specific procedures of rendition to justice, they must comply with the criteria that I have just set. So that means you can circumvent the extradition procedure, but at least, because there is always arrest and detention involved, so at least this criteria of legal basis, not arbitrary, judicial control, habeas corpus, must be in place.
So some of the persons who have faced rendition to justice or even extraordinary rendition have fortunately survived the process to take cases before the court. Can you give some examples of those cases?
Yeah, I suppose you mean the European Court of Human Rights, because there have been several cases. Some of this...
and the one in Italy.
And the one, and that's one, yeah, of course, it did not went to the European Court of Human Rights. Several persons that have been subject or object of certainly extraordinary rendition procedures have used all legal means, so all remedies at their disposal in member states, member states of the Union states, at the international level, in the states also trying to deal with the case over there. The United States is very easy. Because of this doctrine of the Constitution and the Supreme Court, as I told you, national courts in the United States declare always that they do not have jurisdiction. Under civil law, under criminal law, whatever. And there has been not one case in the United States dealing with state liability for extraordinary rendition. And there has been no criminal cases either. In the European context, we have a couple of national cases. The only one that has been fully successful on criminal liability is the case of Abu Omar. That's the one you referred to, in Milan. Abu Omar was kidnapped by the Italian intelligence forces, together with a whole team of the CIA, so the US external intelligence community. Was kidnapped, so was abducted in the legal terms, brought to Germany for a couple of hours to the military basement in Frankfurt, and then transferred for months in a secret prison in Egypt and tortured. He survived. This case ended up in criminal investigations for criminal offenses in Italy. The public prosecutors were quite successful in gathering evidence, and so brought the case to criminal trial. And finally, also an appeal, both the Italian intelligence officers with legal problems because of state secrecy, and the CIA agents, more than 20, were convicted. The problem with the CIA agents is that they are abroad, and that Italy, that's then a political decision by the government, did not ask for extradition. Anyway, it's quite sure that the US would not agree to that. That's, let's say, a nice example of domestic proceedings. Some of these victims or subjects of the extraordinary rendition procedures also, after having exhausted all national remedies, mostly remedies that at home did not work, like in Poland, like in Macedonian cases, ex-Yugoslavia cases, then after having exhausted all the national remedies, they went with a claim to the European Court of Human Rights, so claiming that substantive human rights had been violated. There are a couple of cases now. I have knowledge of two cases that are, one has just been finalized by the European Court of Human Rights, the Grand Chamber, another one is still pending. That's the Al-Masri case, and the other pending one is the Nashairi case. The Al-Masri case, the court has ended up in the Grand Chamber, which is, of course, is important, in a constatation of violations of a whole list of substantive human rights, going from, of course, right to liberty, unlawful detention, illegal transfers linked to liberty, but also Article 3, torture, lack of positive duty, because Macedonia, of course, has, when it comes to such a serious breaches of human rights, a duty to investigate, prosecute, and punish, also with criminal liability, also under criminal law. These cases, the investigations in Macedonia did not run very well, because the military did not want to cooperate, of course. So they were stopped. That's, of course, that's also a violation of the Convention of Human Rights. The Nashairi case is running.
Okay, so what was the political reaction of the international community when these facts became clear to the public to a certain extent? Or, for example, what's the level of involvement of European states, or is there some type of political supervision over this scheme?
Yeah. When the first, let's say, the first 10 years that this was happening, first we had, of course, individual cases, but then it became clear to a certain extent that it was a program. And it has been later in 2006, it has also been declared by the US government that it was a program. So then it became clear that this was a systematic approach. It has been a double reaction, at least in Europe. There has been a reaction, let's say, at the supranational level. Then I'm referring to the Council of Europe, and to the Parliamentary Assembly of the Council of Europe. I'm referring to the European Parliament of the European Union. So you could say that the supranational parliaments have been very active in fact-finding, what happened. So they established, let's say, commissions of inquiry, parliamentary issues of inquiry with experts to figure out what happened. And they have been quite successful. So a lot of things we know thanks to these investigations, parliamentary inquiries, on a supranational level. And of course then the mechanism of political overseeing by this parliament. So they are pushing and pressing their states. At the domestic level, it has been much more difficult. I have no knowledge of any parliamentary inquiry at domestic level. The governments have been very active in hiding the information and not cooperating. But of course, because many facts came to light thanks to this supranational inquiries, they had to move. So we know a lot today, and the political oversight has been strong at the supranational level. The follow-up, of course, that does not result automatically in proceedings against states or proceedings about criminal liability. That's something else.
Okay, now a more technical question. Supposing that the agents of state A are involved in such type of conduct, in extraordinary rendition abroad. Now, under international human rights law instruments, how do we establish the jurisdiction of state A, considering that the act was an extraterritorial one?
Yeah. That's a very technical point. It's also an important point. It has to deal with... Many people think that when you have universal human rights standards, that they apply everywhere in all situations. So that you have universal standards does not mean universal application. Legally, these are very, very different things. Because human rights standards apply in the territory of every party state. That means human rights do apply in Turkey, in Turkish territory. And they do apply in Germany, in German territory. That's the principle. That's the starting principle. So you have a territorial application of universal standards. However, there are a couple of exceptions that have been elaborated not in the text but by case law, so they're Praetorian. And we see quite a similarity as it stands today between the Human Rights Committee of the United Nations, so in Geneva, let's say the Commission and the Court of the Inter-American System, and then the European Court of Human Rights. In the sense that there are situations in which agents, or civil servants if you want, from a state that are active abroad, it can be in very different situations. It can also be that they are active as military personnel in Afghanistan. It's the same problem. They are active abroad. This can trigger extraterritorial jurisdiction under the human rights instruments, under the condition that the state has authority over the situation. Like in Afghanistan, this can be complicated because the UN can be having the authority. So it must be direct authority of that state. For extraordinary renditions, not a problem. They have ordered it, they have authority. And they must have control, de facto control, over the agents acting. For extraordinary rendition, that's also not a problem. They're executing a program. They have authority and there's functional control. In that case, all these committees and courts are accepting extraterritorial application, so extraterritorial jurisdiction under the human rights instruments. So that means that in that situation the standards do apply.
Okay. So maybe
Kaç tane daha soru var?
this, the final question. As a final question, Professor, now another concept connected with the fight against terror has been that of enemy criminal law. It is a concept that has generated major discussion over the last 10 years. Now, what is the rationale behind this concept, and what would be your position on creating such concepts?
It's a very interesting question. It's not an easy one, because the enemy element is coming from two different areas. One is coming really from policy. And I'm referring to the enemy combatants under the US anti-counterterrorism law, where you in fact say, if people that are active in the battlefield in Afghanistan, or people that are active in terrorist circles, although they are not in the battlefield, they are our enemies. That means even if they are in the battlefield and you detain them, you arrest them, they are not war detainees. They're not persons acting in an armed conflict. By calling them enemy combatants, you exclude, at least that's the aim of the US concept, you exclude the application of international humanitarian law.
So despite the fact that they're combatants, de facto you deny them the right deriving from that status under international law.
From the Geneva Conventions. And in the US then, it has another consequence, but it's a domestic consequence. You don't send them to criminal trials. You don't send them to martial trials, so to military criminal law. They send them to military commissions in Guantanamo. So they have invented a third system for them.
So many human rights guarantees normally applicable under domestic law disappear.
They're all out, because they have invented a new concept, a new legal concept. That's the US tendency towards enemies. But there's a much broader concept that has its origins mostly in doctrine, so in legal writing, with a strong, in fact, it goes back to Jacobs in Germany, which is the legal, let's say, the legal theorist of the Feinstrafrecht, the enemy concept in criminal justice. I would say the basic concept is that persons that behave in a certain way, you could say in an extremely antisocial way, that do not accept the basic social norms of society, and by contributing to terrorism, they do not accept basic rules of society. The reasoning is that they put themselves outside of society, and by having put them outside of society, they do not deserve the protection given by law and the rule of law, because this is part of the social contract. They are out. Once they are out, you do not apply all the guarantees, and then you can apply special measures. They lose, you can say this is a provocative, but it's to understand it, they lose the status of person having legal rights. They become an object.
How far is that rationale accepted in criminal writings? Is it rejected by the great majority, or would it be favored by many?
I think in the great majority it is rejected, both in Europe, in the United States, and Latin America, and so on and so on. But there is a school, of course, defending it, and it has to do with a major debate. If you have to deal with emergency situations in the field of terrorism, there is of course a school which goes back to Smith, to the constitutional theory of the beginning of of the last century, saying the best way to deal with these emergencies is to put the Constitution, or substantial elements of the Constitution, between brackets for a period. So that means forget about law, deal with the problem, and we come back to the democracy. That's the basic reasoning. But this is a real minority. But it does exist, and it has a scholarly support, even at the most famous universities in the world.
Thank you very much, Professor, for the wonderful conversation and for coming to Turkey.
Thank you, Moreto. It's a pleasure to be here, and it's a pleasure to be received by such a nice colleague.